Good afternoon. My name is Gabor Lukács. I am the president of Air Passenger Rights, and this is your bi-weekly Air Passenger Rights update live on Facebook. I would like to welcome you all who have tuned in. And first of all, I would like to thank our volunteers, Terry, Christine, Marty, and Dominic, who have been very actively helping as usual through the past 2 weeks. And some of them are actually joining us live on this show in the background, helping to answer questions, helping with the tech. So I'm going to wait to hear for some thumbs up to hear, and I'm being told already by Martin that we have sound and image great. So we are going to just start in a moment. I would like to make sure that everybody who wanted to was able to tune in. And the topic that we are going to talk today about mostly is credit cards. Over the past few weeks, months, it is becoming more and more clear that in terms of the redress, the remedies available to us passengers, when airlines are refusing to refund the money that is owed to us, credit card chargeback is a prominent tool. It is not, of course, a standalone tool, and we have also seen some positive developments from the European Union, putting some pressure on WestJet quite successfully. On Air Canada, less successfully, but some movement seems to be visible there. And Air Transat, we have also seen some literally half-baked, half-assed attempts by Air Transat to comply, at least with respect to flights departing from the UK. We have seen the number of those emails where Air Transat is incorrectly misleading the public to believe that you can get a refund only for your segment departing from the UK and not from the return flight on the same ticket if the segment departing from the UK has been cancelled. But overall, we are seeing some progress on the regulatory front. We are also, of course, fighting on the regulatory front in the US with the US Department of Transportation and some of Air Canada's Air Canada-like comments and attitudes there of trying to poke the US Department of Transportation in the eye and telling them you don't have jurisdiction have already been noticed by the US media, by commentators. So Air Canada is just behaving like Air Canada, and it is, I would say, quite good to us passengers because it is garnering outrage south of the border. As you know, the American Society for Travel Advisors have been calling out Air Canada for refusing to provide refunds and refusing to comply with the USDO Department of Transportation's enforcement notice. So that's one front, but today I would like to talk about the other front, the other very important front, and that is how we deal with chargeback through credit card. So I understand that there have been some misunderstandings going on about what credit cards are, how they work, and that's what I'm going to try to dispel today. So I'm going to switch now to this Blackboard style platform I was able to get to help you understand how banks or bank account differs from credit cards. And of course, credit cards can sometimes be issued by banks. So the question is not simply who issued the credit card, but rather the fundamental difference between a credit card and a bank account. So in a bank account, you simply put in your money. That gives you some balance, and then when you want to make a payment, you can take out the money. Whatever money is there is your money, undoubtedly. It is not a loan, it is not questionable, it undoubtedly belongs to you. And generally, money that is in your bank account is presumptively yours. And of course, there are all issues of overdraft, and that is an additional aspect that I'm not going to address today, because overdraft is more of a loan, and I'm not addressing lines of credit either, which are also a loan. The regular checking account, savings account are all about money that belongs to you. On the other hand, with a credit card company, that is more like a line of credit. The key word here is, of course, credit. So the key word here is credit, and what it means is that they are extending to you, the credit card company is extending to you a credit, a loan, and you can use that to make various payments to airlines, to your shopping, to your various bills that you have to pay. And then at the end of the period, you are paying the credit card bill from your bank account. So the money on your credit card and the statement the credit card is sending you is really a list of what the credit card says you owe them and on what basis. So for example, if you went to buy groceries, you bought 4 liters of milk, and here in Nova Scotia it's around $5.69. So that the $5.69 would show up on your credit card statement with the name of the grocery store where you use your credit card, and at the end of the month, if that was a legitimate charge, if you really bought that 4 liters of milk, you would be paying that from your bank account as part of paying your credit card bill. At the same time, the credit card statement is not some kind of conclusive, immutable document that in and on its own, without context, imposes on you the duty to pay, nor does it take away from your money. I'm not by any means suggesting that you should be skipping paying any legitimate debt. That would be unlawful, unethical, and I am not to be misunderstood that way. However, if, for example, you see on your credit card bill a $5,000 for jewelry that you never bought, never received, never authorized, I would tell you don't pay it. Of course, there are there are standard procedures for dealing with situations that when the credit card company shows a statement, transaction in your statement, which is illegitimate, you notify them, no, I didn't authorize it, no, it wasn't me, please deal with it, I don't owe you that money. So the first important takeaway from here is that credit card statements, unlike bank statements, are not about how much money you have, but how much money they say you owe them. And that's a big difference. So in a bank account shows, essentially, it tells you how much money you have. While the credit card statement normally shows you how much money you owe. A clear distinction is about what they claim you owe. The credit card statement is merely a statement on what the credit card's opinion, thought, claim, allegation is as to what you owe. Under normal circumstances, that would coincide with your understanding of what you owe. Why? Because you are a reasonable, law-abiding citizen, and you know that if you bought that milk for $5.69, you will have to pay to your credit card, and you are going as a good citizen to pay for it. The statement matches transactions you made. The statement matches the goods that you received. You actually did bring home that bag of moo juice and you drank it. So that way, it's quite clear that in that case, a credit card company is asking you to pay, claiming from you something to pay, which actually is owed to them, because that money went to the store gave you the milk, so that there's a complete circle. I'm not sure if I can draw it here, but let me try to draw it here. The model that this money in this case went to, say, a supermarket, here's a supermarket, and it went to a supermarket, and that supermarket actually gave you the milk. That milk went to you directly. That was the milk, and therefore there is a perfect circle here. You got the milk, the merchant got the money from the credit card company, the credit card company got the money from your bank account. Everything is in balance. Everybody got what they were supposed to get. That's a normal course of business. But what happens when you don't get the actual service for which you have paid for? So what happens if we don't have this? Well, that is where chargeback comes into play. So the purpose of chargeback is to deal with this transaction here. The chargeback is a procedure by which the merchant is forced to give back the money to the credit card company, and therefore you don't have to pay the credit card company either. It is also a right in most Canadian provinces. It is a right, and we are going to talk about the Ontario situation a bit later. It is a right under provincial consumer protection laws, basically. Some provinces have laws that require all chargebacks for all future performance contracts. Others apply only to distance sales contracts. So for example, if you buy something on the phone or on the internet, yet others apply only to internet transactions. They vary from province to province, but the general principle is, and that's a common principle, that if you buy something on the internet and that doesn't get delivered to you, you have a chargeback right. It's not simply because your credit card company is being nice to you because they want to help you. You have a chargeback right because this is the law. So back to this diagram, which already turned into quite messy. Once you don't receive the goods, so if you're not receiving those goods, let's erase that. Then the credit card company can say, okay, that's nice, but then the merchant is not getting the money. In other words, more precisely, what will happen is that the credit card company is going to take back the money from the merchant. That's the normal course of business. But what happens if the credit card company, like it happened, some of you tells, you know what, take a hike, we don't care, you just sort it out with the merchant. Well, the normal course of events is then to write a rebuttal and to demand that the credit card company comply with the law. But if they are still not complying with the law, the next stage is clawing back the money from your credit card. What this means is that you are saying that this step of the payment from a bank account to a credit card company is gone. Your credit card company can still send you a statement saying you owe us so much money. That's all fine and dandy. But you on your part saying you are not paying. So you are saying here that this stage is not taking place. The credit card company, of course, is not going to just let you necessarily off the hook. They have the right to go after you in court. What they cannot do in most Canadian provinces is harass you with collection. If you advise a collection agency that you want them to take you to court over a debt that you dispute, they have to leave you alone. So all this fear about possible collection over a transaction that you can legitimately dispute because you didn't receive the goods is somewhat exaggerated. Yes, some of those collection companies can be very painful and they may not follow the law, but I would have no hesitation calling the police on them if they come to harass any person who has taken the proper procedures to ensure that they cannot harass you anymore. So what happens now when you refuse to pay an illegitimate charge? And let me stress again I'm only talking about refusing to pay an illegitimate charge, something that you didn't receive the goods for, didn't receive the services for. This is not a way of playing games. This is not to be taken lightly. I'm only saying that if you have not received the goods, you have exhausted all your avenues of chargebacks and the credit card is still stonewalling you, then you simply say, I'm not paying you the amount in dispute. I would still pay every other debt, every other amount that is owed, but not that specific amount. Now, what I've been asked is, okay, but they will charge you interest. But let's do some reality check. What does charging interest mean? The credit card company has no access to your bank account. They cannot simply pull out money from your account. They would need a judge to issue a court order before they would be able to access your bank account. So when they say we are going to charge you interest, all this means that the credit card company is going to add a few more lines to your to your credit card statement. They're going to tell you, well, now we are going to also claim from you another, whatever, say $200, I'm just making up a number, that we are saying now that you owe us this $200 more. Does it mean that you actually owe them that money? Absolutely not. The only thing that you really owe in a legally enforceable way is what a judge has ordered you to pay. Let me stress again, I'm not suggesting to abuse it in any way. What I'm talking about is the last ditch effort, the last line of defense against illegitimate charges. And you have to be positive and sure that you didn't receive the goods or services for which you are applying this. But the credit card company says, well, we are charging you $200 of interest, say. And your response is, I don't believe it's a legitimate charge. I don't recognize it as a legitimate charge. If you don't like it, take me to court. That's the key message, that if things really break down in the normal line of communication and business between you and your credit card company and you claw back amounts, you need to communicate in writing that you are considering the charge in question, that specific one or two charges, one or two transactions, illegitimate, explaining why it's illegitimate, maybe refer back to a previous rebuttal letter that you wrote. You state that this was illegitimate, has no basis, and because the credit card company is not doing their job under the provincial legislation that requires chargebacks, you are therefore not recognizing that transaction as valid. You deny owing that amount to the credit card company and that they have to sort it out with the merchant. I can tell you that the credit card companies will not be happy about it. They may send you some stern letters telling you that we are going to go after you, do this, do that to you. Part of it is saving face, part of it is intimidation. Credit card companies are used to dealing with people who are not paying because they cannot, because they maybe don't have money. And with those people where the charges themselves are legitimate, this type of pressure techniques may result in some success, because when you have a legitimate debt, something that you really do owe to the credit card company, they can easily get a judgment because you don't dispute it. But as soon as your position is not that, sorry, I don't have money, but rather, no, I don't owe this money to begin with because I didn't receive anything in exchange. That is a game changer. Then it is a disputed, contested debt, and then they have to go through the full legal procedure of getting a judgment against you, filing court papers, then you file a defense, then there has to be a trial. They cannot simply claw money out of your bank account. And that can be a very powerful tool in dealing with credit card companies that are being very aggressive in refusing to provide chargebacks as required by law. But I would like to also show you, I'm going to go now to the Ontario Consumer Protection Act, and we're going to look at that together in a moment, but I'm already seeing here some great question. Chargebacks in the case of debit cards are way more complicated. Debit cards work directly from your bank account. So in the case of debit cards, once the money is taken out from your account, it is not just a debt, it is out from your account. You no longer have that money. Even in case of bank account, sometimes you have a chargeback, and if you take out the amount of the chargeback, well, and then the bank decides to change its mind and says, actually, you owe us that money, you end up in an overdraft situation. It becomes much more tricky, though. If you do have, based on the terms and conditions of your debit card, some Visa debit cards have that, a chargeback right, and they are not complying with those, then I would become quite aggressive and say, you know what, I'm not going to pay this amount. You claim I have a minus now, I have an overdraft now. I don't recognize it, it's not valid. You didn't perform your duty under the terms of the contract. But if you are dealing with a debit card, then in many cases, and this is something to look very carefully, you are not subject necessarily to the same level of protection that you would have if you were working with a credit card. Pat is asking, as you know, all credit cards institutions are based, i.e. BC Financial, BMO, Canadian Tire. Why is it that one thing they have in common is that they are all MasterCard? However, they all treat their clients differently. Why don't they all apply MasterCard International rules? Well, Pat, you're asking a very good question. So the question here was why those credit card companies are not applying the same one and the same standard that MasterCard International prescribes. And the answer is because either they are misinformed, that's certainly a possibility, or they may have other vested financial interest in hindering chargebacks, perhaps because of their financial ties to some of the airlines, some of the major travel service providers. There can be many questions of this nature. I don't know what is happening in the background, but I have seen, however, that if we provide sufficient evidence that this is happening to MasterCard International, I have seen quite a level of willingness on their part to take action against their own partners in a very silent way. You would never see it anywhere in the press, but they will pick up the phone and tell them, hey, you need to fix this. So in that sense, if you see problems and you have evidence of it, please let me know. With Rogers MasterCard, I've seen quite a bit of improvement. With PC Financial MasterCard, same thing. With Tangerine MasterCard, I've seen the same thing. With BMO MasterCard, I haven't managed to speak to someone higher up in the food chain. They have been kind of stonewalling me. But I do believe that they changed their stances because of MasterCard International and the recordings of calls that we provided to MasterCard International. Cindy John is asking, so are you saying that if I take a cash advance of my credit card for the cost of my flights, that is, I didn't receive illegitimate charge, they should not charge me interest for that? Cindy, I would be careful with cash advances. The way I would deal with it is that I would wait first until you get the temporary credit, which then brings your balance into credit balance on credit card. In other words, situation where the credit card company owes you money. And if the credit card company owes you money, even according to their own statements, then it is definitely safe to take a cash advance. Taking a cash advance as a way of clawing back your money is a kind of last-ditch effort. I would not use it unless you have a credit balance, positive balance already with a credit card. If you want to claw back money because they are being combative with you, I would rather simply deduct the amount of your flight from your next bill, and at the same time advise a credit card company why you are doing it. And again, Cindy, just to be clear, you do this type of steps after you have exhausted all your steps to the chargeback, and even then you make sure to put it into writing what you are doing. So it is not simply, I'm not paying. That would be a mistake to do. The proper approach is to deduct the amount in dispute from your next bill and advise at the same time in writing your financial institution, the credit card issuer, why you're doing it and what you are doing. That way you have a paper trail that you are not a delinquent debtor, but rather there is a genuine dispute. Creating this type of paper trail is a very important step. And at that point, if they try to phone you, I would tell them, sir, madam, thank you for your call. Put your position into writing. I have done my position. I've already done that. I've put my position into writing. Let's have a full paper trail. If things go to that point of you have to claw back your money, then there's no point in continuing, of course, having discussions on the phone. Maria Cho is asking a question. Gabor, there is something called the right of offset that allows the bank to withdraw funds from your account to pay for credit card if the bank is the issuer of the credit card. This is Manitoba. Are you aware of it? No, I'm not aware of it. This right of offset is something that may exist in other commercial contexts with your bank account. If there is a dispute about it, I don't think that such a right would necessarily exist. I would say that actually you're exercising a right to offset when you're clawing back money from your credit card. In practical terms, the bank has some fiduciary duty to you, and it's a very interesting question, Maria. I would suggest that also after this session is over, we look into this further. I would want to find clear grounding for this in the terms and conditions. But if you're worried about this situation, just move your money to a different bank. Problem solved. Again, those are not the normal business dealings that we are seeing today. These are extraordinary measures that we may have to take. But if the credit card companies, or some credit card companies more precisely, and credit card issuers want to endorse theft of your money, you have to protect it. This situation is very much the same as your car, which you left in a parking lot and they are refusing to let you take it. You walk in there, you get in your car, you drive out. You put your car in your garage. If they don't like what you have done, let them get a sheriff, let them get a court order, let them deal with it through the proper legal system. But by the time your car is back in your garage, in your house, in your physical control. Same thing with your money. And for people, if you have, I think, Maria, you raised a very good question, this right of offset. Let's investigate it further, but there is a way around it. Just open a different account in a different bank, take out your money from that given bank in question, possibly then move all your, if you have investments, just move it elsewhere. Tell them also while you're doing it, you have not been treating me well and moving out my investments. They will definitely be taking note of that, and they will realize that they cannot treat customers the way they are doing. Jeremy is asking, if I let them sue me, will they go to court where I need a lawyer? Should I not sue them first in small claims along with a vendor? Jeremy, most provinces would really frown upon a credit card company suing you in Supreme Court, Superior Court over a $2,000 debt. That would be truly extraordinary. So in many cases, you can actually move either automatically or very simply any such case to small claims courts. Generally, I would prefer, if I were in your shoes, those companies to be the ones suing me. That is always a bit of an advantage. As a defendant who is disputing the amount that they are claiming, who has a whole trail of documents about what they are claiming, you may be a little bit of an advantage if you have done your homework properly, if you have the full paper trail. And one more thing you could do is have a third-party notice, if it's permitted in some provinces, to the vendor. So bring the vendor in, then into the proceeding possibly. That's a strategic decision you may or may not want to do. And say, well, this is really not the dispute between me, it's really between the vendor and the merchant and the credit card company, and they have to settle it. Here's my evidence. I didn't receive the service. These are the laws of the province. Let's move on. That's the type of approach I would take. Now, Dushan is asking, thank you for explanation of the cards. Speaking of debit cards, CIBC told me that if airline ticket is involved, there is no more upfront payment. I know of 2 people that got their money back after checking, but bank took it back. Is it normal? Well, Dushan, I would say that when you get back the money to your checking account, and especially if it is controversial, take out the money and empty the account. Leave an empty account there. If they want to take back the money, they will not take back any real money. They are just going to have an overdraft, minus. But a minus balance is not real money in the sense that it doesn't hinder you from continuing to spend money on your daily needs and what you need. It means that they may be able to claim something or try to claim against you down the line. Let them be. If that's what they want to do, they will have to vindicate that claim in court. So every time every time money is in your hand, it's a good situation, because that means that the vendor and the credit card or the bank are the ones running after the money, not you. It puts you in a way better situation practically, because I don't think you are alone. I expect there will be hundreds, if not thousands, of people all in the same situation. The banks, the credit card companies don't have the resources to fight that many cases, especially if it becomes a trend that every time they refuse a proper chargeback, and I'm referring here to a proper legitimate chargeback, then people just claw back the money. If it becomes a widespread phenomenon, and we're talking about millions of victims across Canada, if 10,000 people do it across Canada, credit card companies will have a very hard time to cope. If 100,000 people do it, they will have to surrender. Why? Because 100,000 separate small claims against 100,000 separate credit card holders, it's not going to happen. It's unrealistic. So part of the purpose of this, besides protecting your money individually, is to change the path of least resistance. Earlier, it was asked why some of those companies are doing this. And the answer is, for the time being, it looks like we passengers are the path of least resistance. If we can change that, if we can cause the path of least resistance to shift from the passengers to the actual vendors, then the credit card companies all of a sudden are going to see the light, and they are going to start demanding the vendors, the airlines, to pay back passengers indirectly to pay them back. No bank will want to hold the bag for those airlines and travel companies, I'm referring to tour companies, that have been engaging in questionable conduct. The banks are such a champions of the cause of the airlines only as long as it serves their interests, as long as they don't have to pay for it from their own pocket. So turning the tables on the credit card issuers, on the banks, and creating a situation where for every dollar that you don't get from the airline, the banks, credit card issuers end up seeing it as a net loss, is a winning strategy, because then those banks that are very powerful and have a very strong lobby are going to start lobbying for you, for us, for passengers, that the airline will be required to provide a refund. I would also like to go to, because there's one more question here, I'm going to answer that, I'm then going to talk a little bit about the statutes. So Tim Williams is asking, the right to offset isn't valid with AMEX possibly. AMEX is their own bank, right? Well, Tim, I know that some people have both a credit card with AMEX and also have a bank account with AMEX. They keep their money. In a situation where you have a dispute with AMEX, the first thing I would do is move out all money from any bank account you have with American Express. If you have any bank account with them or any entity affiliated with them, that would be my very first move. Next, I would like to share with you some things that I found in the Ontario Consumer Protection Act. I'm just going to, I need to a bit reshape here the window. Just bear with me for a moment. Bigger. All right, so I've picked the Ontario Consumer Protection Act because in some ways it has the strongest wording, but there are a number of similar statutes across provinces, and credit card companies really don't like the idea that they have to comply with it, but there are a number of Supreme Court decisions from 2014 that actually do require credit card companies to comply with it. So let me just first make a bit of a detour there. So there was some 2014 Supreme Court of Canada Consumer Protection Act, AMEX. So there's a nice article actually by McInnes Cooper law firm, which lays out these 2014 cases, which also, by the way, involves AMEX, Bank of America, and Bank of Montreal, where the bottom line was that provincial, in that case Quebec's Consumer Protection Acts, apply to those banks, even though the banks are federally regulated. So the financial institutions argue that no, those things don't apply to us because we are federally regulated financial institutions. But the Supreme Court of Canada agreed with the consumers that those laws actually do apply. And so, as correctly pointed out by the author Kevin Kelly, even in Ontario, which has similar legislation, Atlantic provinces, the same conclusion would apply. This was about disclosure provisions and the exchange provisions, but the principle that just because it's a federally regulated institution, that doesn't mean that they are not accountable to provincial law. If they come to your province to do business in your province, oops, that switched back. I need to fix that. So if they come to your province to do business in your province, guess what? They have to act like they are in your province. They have to respect your province's laws. Let's come back here, hopefully, and hopefully this time it's going to work. Okay, so let's go back to the Ontario Consumer Protection Act of 2002. There are a number of provisions here which are important. The first one, which credit card companies and merchants both love to forget, is Section 7 sub 1, subsection 7 sub 1, which says that the merchant and the credit card issuer cannot contract out your rights under this act. In other words, whatever nice verbiage they put in the act about the dispute being only between you and the merchant, about them not owing you anything, that you have to resolve with the merchant, it doesn't matter. Whatever rights you have under this regulations, you have, and under this act, you have regardless of whatever provisions you may have in a contract. Something else worth noting, although it's not relevant to today's discussion, is that there is also a provision here that prohibits or renders void any type of anti-class action provision in your contract. So if you ever have a concern about what you're signing off in Ontario that says you cannot bring a class action against the company, well, they haven't read the Consumer Protection Act. They don't know what they're talking about, because you do have a right to class action. The next provision that is of interest is Section 26, which deals with late delivery. So it deals with a future performance agreement. And a future performance agreement, let's just find it. What does it mean? So future performance agreement. So it is defined as a consumer agreement in respect to which delivery, performance, or payment in full is not made when the parties enter the agreement. That's a very broad definition. There's a whole host of rights about future performance agreements. The most important here is with respect to late delivery. And it says that if the supplier does not begin to perform his or her obligation in 30 days of the commencement date specified in the agreement, or an amendment commencement date if agreed by consumer in writing, then the consumer has a right to cancel the contract. So this would not necessarily cover you if they're telling you, well, it's in Ontario, if they're telling you, well, we're going to fly you an hour later, but if they cancel your flight and they're telling you, well, we won't fly you now and not later, then certainly this gives you a chargeback right. Now, what happens once you exercise that right to cancel? Then the merchant has an obligation to return to the consumer any payment made under the agreement or any related agreement. Let's read the words again. Refund to the consumer any payment made under the agreement. So in other words, if you give them dollars, they have to give you back dollars. They cannot give you vouchers. Why? Because the act says that the merchant, the vendor, has to refund the consumer any payment. Refunding a payment means giving back the actual payment. And I've seen your question. We're going to talk about timelines in a moment as well. Now, what happens if the merchant doesn't comply with it? Well, that's where Section 99 comes into play. A consumer who has charged to a credit card account or part of a payment described in subsection 2 may request the credit card issuer to cancel or reverse a credit card charge and any associated interest or other charges. And this applies to payment in respect of consumer agreement that has been canceled under this act or in respect of any related agreement. Or payment was received. These are less relevant to the other 3 points. You could also argue, by the way, that if they provide you with a voucher, it would be a form of unsolicited goods, which is an angle which we haven't explored. But certainly, if you didn't want vouchers and they give you vouchers, it's a form of unsolicited goods. Now, once you make that, so just to go back to Section 96, here, action. My recollection is, and I don't know where I saw it, but I recall that there was a 15-day deadline for the merchant to comply with this refund obligation. Reasonable care, home obligation, no further obligation. And once they have not complied with it, then the chargeback starts. So the consumer may make a request if the consumer has canceled the consumer agreement or demanded a refund in accordance with this act, and the supplier has not refunded all of the payments within the required period. Now, required period is, I believe, 15 days. And then you have a clock. So the time between, so in terms of timelines, there is first, I believe, and we are going to double check it, 15 days for the merchant to issue a refund. Then, under this act, you have from that time that the time to issue the refund has expired, you have 60 days, as I recall, to start your refund. And then the credit card issuer has an obligation to acknowledge within 30 days your request. And if you meet the requirements of Section 4, then cancel the charges, or after having conducted an investigation and a written notice to the consumer, explain the reasons why the credit card issuer is of the opinion the consumer is not entitled to cancel the consumer agreement or demand a full refund under this act. So as long as they don't meet this requirement, you are quite in a good position. Of course, you can commence an action against the issuer for recovered payments or interest to which you are entitled. You also have a right to start an action in the Supreme Court of Justice in Ontario. And if you're successful, you get back many other things, interest, any payments, and so on. So I was asked now a question about deadlines. Let's look at the deadlines. And Susan, I'm going to deal with your question too. So the question was what the deadlines are. I'm going to duplicate this tab and let's go up here to look at the regulations. General regulations. There were a couple of deadlines here that are of interest. So specific consumer internet agreement, direct agreement, remote agreement. I'm just skimming through. It will be around Section 85 if I recall correctly. There we go. Cancel time for refund. So for the purpose of subsections 98, sub 2, and 4 of the Act, the refund shall be provided within 15 days after the consumer demands it under subsection 98(1) of the Act. So if you demand, and let's go back here what section 98 says. So if you demand from a merchant, that's for illegal charges and payments, that may not be the right thing to look here, actually, but just to be clear, that would be a good guidance for sure. It would be worth, let's make a note of it, that it would be worth checking what is exactly the deadline for refund under Section 96. So would it actually apply charge fees? It is definitely worth checking what is exactly that deadline is, because I'm not sure if it's specified. It's an interesting point. But maybe it's going to be answered here. Let's just see. Limitation. No, that's not that. But let's look now at what the timelines are. So for the purpose of subsection 99.4, that's your notice to chargeback. So that's 99.4. That has to be given within 60 days after the end of the period in which the supplier was required under the Act to refund the payment. And they prescribe here what information you have to provide to credit card company. And the next important information is that they have 30 days to confirm receipt of your chargeback. And the time, I think hopefully this will answer the question of Susan, not Susan, answer of Ashley. The time for providing a chargeback is, it starts when the consumer request is given to a credit card issuer and ends on the date of the second statement of account that a credit issuer delivers to the consumer after the consumer's request was delivered to the card. So it's about 2 statements. That's how much time they have, but that's after you've delivered something to them in writing. So in case where they are not even processing things for some reason, if you want to be super sure, deliver also a notice in writing to your credit card issuer and set out all the details here, set out under Section 85 of the regulations, and send it to the credit card company, and then you can definitely trigger some tight deadlines. Now, question by Susan about Section 46 of the Ontario regulations. Ontario regulations Susan's referring to, it is about regulating travel agents, not about regulating credit cards or consumers in general. So those regulations, my argument would be as follows. First of all, the laws in place when the contract was made are the laws affecting your rights. If at the time when the contract was made, there was a right to a refund under Section 46, you have a right to a refund now. It's an acquired right. The second point is that regulations cannot be retroactive. Laws can, within certain circumstances, possibly, if Parliament passes it in a particular way, but regulations without legislative basis cannot just go back in time and change already concluded contracts. The third point is that those regulations cannot alter the clear and unambiguous words of Section 96 of the Consumer Protection Act, which requires a refund to the consumer of any payment made under the agreement or the agreement. So I think that it's a way, it's a bit more sophisticated than the CTA's statement on vouchers, but legally it is equally dubious. Brian Schuster is asking, if there is no reality to credit card companies to go after each individual in court to get their money back, do the credit card companies go after relevant airlines, go to court to get their money back? Well, Brian, I would say that the credit card companies have a good basis to go after the airlines, and it would be more worthwhile for them to go after the airlines if there are a sufficient number of passengers who are refusing to pay illegitimate charges. If there are enough people objecting to what these companies are doing, then the path of least resistance is no longer the passengers individually, but rather the airline. And the airlines will be crucified not even necessarily by the banks directly, but through the court system and the government, because the banks will want their money back. And if the airline's behavior is pitting them against the banks, the airlines are going to likely lose. Banks are probably stronger than the airlines. The banks are way more powerful in Canada than the airlines. So this is a bit similar tactics as what seems to be developing between Air Canada and the United States Department of Transportation. Air Canada had such an aggressive, belligerent attitude with the U.S. Department of Transportation that they have set themselves up for some trouble. They told the U.S. Department of Transportation to get lost, basically, and that's not going to fly too well, I think, in the United States. So if we can create a situation where the airlines and the banks have conflicting interests, we are going to start seeing more refunds, even if every other effort were to fail. And to be clear, I just wanted to mention in passing that we do have now a certification motion set down for, this has changed to the 2nd to the 4th of November this year, where airlines will slowly but surely have to be given account of what on earth they are doing. They will have to explain to a judge of the federal court, how do they imagine to keep the money from passengers who never received the service they had paid for? Other question by Helen is, has anyone addressed with the airlines, the Ontario Consumer Protection Act? How can we file complaints to the Ontario Consumer Protection people? Helen, I would not hold my breath about the Ontario Consumer Protection people. They are, unfortunately, as we have seen also in those regulations, seem to be more keen to help the airlines, to help the rich, to help the powerful, than actually helping consumers. But the act can also be used as a shield, not only as a sword. The way is to first claw back your money, make sure that you have that money, use that money for your purposes. And then when a bank, credit card company tries to come after you, use it as a shield. Use it as a way to say, well, they didn't follow the law, and possibly if they sue you, perhaps file a counterclaim. That may be the easiest, most economic way, and also third party, the vendor. So create a lawsuit where you are on the defense, they are on the offense, and you bring all the parties before the court. And with hundreds or thousands of those going on, it is going to become unmanageable. So you have a moral right, legal right, plus procedurally, it's very hard for them, because we're talking about a couple $1,000s. Generally, a lawsuit of a couple $1,000s is worthwhile against individual debtors who are generally not paying, and there's no doubt that they owe the money. Once it becomes a genuine doubt whether the money is owed, it becomes a protracted legal proceeding. They have to hire lawyers. The lawsuit costs way more. The cost they can recover is substantially less than the amount in dispute. It is really not going to go anywhere for them. So this is one way to see, to make banks and credit card companies, credit card issuers that are not acting in the consumer's interest, that are not respecting the consumer's rights under law, to start seeing the light. Tim Williams is also asking, would asking for audio transcripts from credit card companies for all calls cause them to become worried and maybe start allowing chargebacks? Tim, getting audio transcripts is always a good idea. Filing also some PIPEDA requests is also a good idea. How much they will do it and how cooperative they will be, it's a different question, but certainly worth doing it. They definitely have to provide you with transcripts. They have to provide you with all records about you. They have to provide you with documents. That's part of your rights under PIPEDA, under the Protection of Information and not sure what other P stands for, but Electronic Documents Act. So it's a federal statute and certainly subject to the banks and credit card companies are subject to it. And getting all those documents, it will not necessarily intimidate them, but they will realize that they are dealing with someone who is willing to go to fight, who is not intimidated, who knows that they are right, that the law is on their side. And I would like to come back in a moment to American Express, but I would also like to talk about a few other things we mentioned, just a quick announcements. The first thing is that I learned about a court case in France, actually, targeting 17 airlines or 20 airlines, I forget the exact number, including Air Transat. And they are seeking there an injunction. I'm going to post here the link if I can. Have a look at that. It's from May, and court proceedings may not be that quick in France, but it's worth looking into this as well. The other thing I wanted to mention before we come back to credit cards is that if you have a flight to and from the UK, United Kingdom, then filing a complaint with the UK Competition and Markets Authority, CMA, in addition to a complaint with the Civil Aviation Authority may be a good idea if Air Canada or Air Transat is misleading you about your rights. For example, if they tell you, we owe you a refund only for the flight segment that was departing from the UK and cancelled, not for the other flight segments. That's a misleading of the consumers. The law is clear under Article 8.1a that they have to refund all segments. We are talking about Article 8.1a of the European regulations, Regulation 261 of 2004. So if they are misleading you about your rights, you should complain to the CMA, the Competition and Markets Authority of the UK, on top of a complaint to the CAA, the Civil Aviation Authority. They are also going to crack down on this type of behavior. They are already cracking down in a very polite, very discreet way. But the reason that we are seeing some changes already with Air Canada and Air Transat with respect to the UK is because those public servants there are actually taking their job seriously and they're acting in the interest of the public and acting like public servants and not as the goons of the airlines, not as shields for the airline industry. Brian asked, based on the CTA's relevant statement on vouchers, can the CTA be sued, maybe for neglect? Well, Brian, you're asking some good questions, and neglect may not be the right phrase, but, you know, let me just say, let's leave all options open. When public officers issue statements that are misleading, that cause harm, knowing that it causes harm, knowing that it's misleading, there can be some remedies. There is a notion of misfeasance in public office. And, you know, I certainly would not want some poor frontline clerk to pay for the faults of people higher up. So that's one concern I would have with pursuing such action. I would not want somebody low in the food chain to be turned into a scapegoat. That would not be right. Nor do I think that the bureaucrats should be paying for the sins of large corporations and of politicians who are pushing them to do things. But I wouldn't rule that out as a possibility. Let's see what we learn in the coming weeks and months about what happened and what actually is going on there. Let's see how these people behave. I would not rule that out. The other thing I wanted to come back to is the notion of social media advocacy. We have been doing really well on that, and round of applause to everybody who participated and participates in that. We are being noticed. We are being visible, and I've spoken to 3 different members of parliament this past week who all mentioned one way or another that they have noticed our efforts and our constant presence on social media. So just because you don't see things changing overnight, it doesn't mean that things are not happening. Things are happening. I would like to point out 2 examples. The first one is the ASTA statement, the American Society for Travel Advisors, which calls out Air Canada for not providing refunds. That came because of the social media attention we managed to draw to Air Canada's unlawful behavior and for Air Canada poking the DOT, Department of Transportation, in the eye. That was the direct reason for it. The other example, which I'm very, very proud to mention, is the recent video that was released today by Prince of Travel, and I already posted it earlier this morning. Please take a moment to look it up. It is a great video that exposes in 18 minutes the whole problem in Canada, not just the airlines, but also how the Canadian Transportation Agency is behaving. Very, very well done, very professionally done video. I wish I could produce something that good. And also very multifaceted, very balanced. It is giving a fair shake to the airlines as well. It is giving them a chance to demonstrate, to explain what they're doing. And of course, It's not particularly convincing, but I would say it's a fair video. I've already seen about 70 retweets of that. If you can, so if you haven't done it, I'm posting the tweet we put out from Air Passenger Rights about it. And if you can retweet it as well now, if you haven't done it already, please do that. The more attention we can draw to this amazing work, and which deserves a lot of credit, the better. The people who made this video deserve credit for their work. You will notice that the video that came out very heavily relied on the materials from our group. So all the information we have in this group, it does not go unnoticed. It helps people who want to raise awareness about our issue, helps people who want to publish about this. And in fact, 3 of the videos that we created, that you created in the group, when you are calling out airlines saying this airline stole this much money from me, have been cited in the in this video clip that I'm talking about. So this brings me to my next request, which is please keep posting those videos. If an airline stole your money, don't be shy to call them out. Please prepare a similar video. I can send you a number of samples for what such videos look like. Make it short, make it to the point. It is very helpful. We have one volunteer in the group, Jeffrey, who has been working on compiling groups of videos from individual videos. Please help him. Please keep up that effort, because even though we don't see the results today, we may not see the results tomorrow, things are changing underneath. I mentioned I've been speaking to members of parliament. We are being noticed, our concerns are being heard, and we have to be the broken wheel, the broken gear which gets the oil, then this squeaky wheel, precisely the squeaky wheel that gets the oil. Brian Schuster is asking again another question. Can the Canadian government at any time do an about-face any time and order airlines to refund passengers? Legally, of course, the Canadian government could do such a thing. Whether political they will do is a matter of how much pressure we can put. The survey that we have published, a screenshot of it from Ledger, it's an independent survey, shows that the government's decision to not force airlines to issue refunds is very, very unpopular. That certainly has been a very good news, and maybe I should show that to you. Let me just pull that up. That was a very nice catch. So let's see, this can close. And no, I would like, I'm going to show you in a moment. I just need to refocus my software on that particular page. So let me try to right size. Okay, so here we go. This is the survey I'm talking about. About 72% of people are opposed to Mark Garneau's policy on not forcing airlines to issue refunds, which indicates that he is up on a wrong trail for sure. The reason I'm mentioning all this is that don't despair just because you haven't received your refund yet, just because we haven't seen the government officially admit that they have done something wrong. It's becoming really abundantly clear that what they're doing is not the path forward. It's just a matter of time, how long it will take until they're forced in some way to reverse course. It may not happen in the most elegant way. It may happen possibly with various other subtle forms, but I have no doubt that this type of nonsense will not survive in Canada of 2020, when the US, when the European Union, or even Australia are taking steps to enforce the rights of passengers. Bob Burrows is saying, we have a Facebook group for UK passengers whose flights were cancelled by Air Transit. Bob, I'm happy to discuss it with you, and how we can share the information, how we can collaborate on that. Certainly, a group which is narrowly focused on Air Transat can be a bit problematic in the sense that it is too narrow in its scope. And I would say that dealing with, it would be important to deal with Air Canada, Air Transat with respect to UK equally. They are both playing the same game now. So I wouldn't single out Air Transat because Air Canada has been, it seems, equally bad with the UK flights. But I'm certainly open to discussion, so feel free to reach out to me. Joanne Flips is asking, will there be a French version? French version of what? I'm not entirely sure, Joanne. Of this survey, I doubt it. We didn't prepare this survey. This was by Ledger. I don't think they put it out in French, unfortunately. I'm wondering if any survey was or will be published in the coming days in French. If there is, of course, you're welcome to post it. Let us know. But speaking of a separate group, I would like to come back to one last topic. We are already a bit over the time we planned for this session. It seems that American Express is the most aggressive, most belligerent credit card among the three major firms, MasterCard being reasonably friendly overall, the international level. Visa is a bit of middle of the road, perhaps a bit pro-merchant, but not belligerent. AMEX seems to be the one black sheep in this whole bunch. And so I was wondering if it might be a good idea to create a separate closed group for AMEX chargeback victims whom I have known already to be affected by these issues, and to look into taking further actions together to bring AMEX into compliance with the law. It's a proposal at this point. If you feel up to it, if you think that you can put some work into creating a nice banner image in terms of writing up a nice description, in terms of keeping on top of things, then certainly I'm very interested to discuss it with you, because we would need more information, more focused information that possibly we can then bring to the press, we can then bring to decision makers to put pressure on AMEX. AMEX has been very much out of line here with Canadian law, and they seem to be acting like Air Canada is acting in the US. They act in a way that, well, we don't care about Canadian law. Well, if you don't like our rules, tough luck. But unfortunately for AMEX, this is Canada, and Canada has its own consumer protection laws. And if they don't respect our laws here in Canada, they will have to go to do business elsewhere. So that's the message I would like to get across to AMEX, and I would like to make sure that AMEX comes into full compliance with Canadian laws and provincial consumer protection legislation. So you are definitely welcome to reach out to me to discuss how we can act more collectively on AMEX, which is a sore spot. I think that that's probably it for today. I'm wondering if there are any more questions here. Probably one of the last questions from Joanne. Quebecers travel constantly. They seem to travel more than other provinces. I will try to find some videos in French. Yes, if you can find videos in French in a sufficient quantity of people talking about how airlines stole their money, that would be terrific. I would love to see that. We could post it on Facebook, on Twitter. Jeff could make this kind of nice compilation for us. So it's a great initiative. And so take away from today, two things. If you think you have the energy, time, desire to get involved with a American Express specific Facebook group that deals specifically with the issues of chargeback with AMEX, I'm welcome to entertain that. I'm welcome to you to contact me, and I would be happy to entertain that. And please post more videos. Diane is asking one more question. How long after a trip has ended can we issue a chargeback? A friend of mine has not started her chargeback yet. Diane, for MasterCard and Visa, they have 120 days from the day of the expected performance. That's their official policy. In Ontario, I would also say that if you have made an official demand, or you can make now an official demand under the Ontario Consumer Protection Act for a refund, then wait 15 days and then just charge back then. So the legislation in Ontario is different than what the airlines are doing, and it may provide you with additional time if you need to get around the credit card's own policies, because credit cards have to follow provincial law, not the other way around. If they don't like provincial law, can go and do business elsewhere. I think that probably that's it for today. I'm still going to give a minute or half a minute to the wonderful team to tell me if there's anything else that we should be addressing, and if not, then we are going to conclude. So Christine, Martin, how do you feel? What do you think is the good time to wrap things up? Are we all done now? And I'm still waiting for an answer, but I'm not seeing any other rush of questions. Status of class actions, I mentioned already. I won't just repeat it once more, that the only update I have today is that the certification motion is set for November 2 to 4, 2020. If there are no more questions, I think it's time to conclude. And I anticipate that unless there are some groundbreaking news, we are not going to have another session next week, but probably we'll be back in 2 weeks for another update. Until then, keep safe, keep social distancing to the extent it needed, physical distancing. Don't fly if you don't absolutely have to, and most of all, take care of your loved ones. Have a wonderful week.